Welcome to The Explainer. Today, we're diving into a multi-million-pound real estate gamble that literally made it all the way to the UK Supreme Court. We're going to look at exactly what happens when you leave the most crucial terms of a massive deal completely unsaid, and how a simple, omission can end up costing you everything. But before we get into the weeds, I want you to ask yourself, would you ever introduce a buyer for £1,000,000 fee based on just a handshake? I mean, imagine putting a massive payout on the line without a single written term. It sets the stage for what has to be one of the most expensive assumptions you could possibly make. It sounds a bit crazy, right? But in the super fast-paced world of high-value commercial real estate, oral contracts actually happen a lot. And let me tell you, when they go wrong, the legal fallout is absolutely fascinating. So let's jump right into part one, the £1,000,000 handshake. To wrap our heads around this super high-stakes dispute, we've got to look at a property investor named Mr. Barton and a company called FoxPace. Mr. Barton wanted a massive fee for introducing a buyer for FoxPace's commercial real estate, a property called Nash House. And I want you to notice the really specific number he demanded, exactly £1.2 million. Now, normally, an agent gets a percentage commission, a standard cut, but Barton demanded this exact flat sum. So why was he so laser-focused on that specific number? Well, the history between these two explains the whole shebang. You see, before he ever even tried to introduce a buyer, Mr. Barton had actually tried to buy Nash House twice himself. Back in December 2012, a company he was linked to exchanged contracts but ultimately failed to complete the purchase. Then, jump to June 2013, he tries to buy it personally. He put down an initial deposit, but he just couldn't make the follow-up payments, so that contract was rescinded too. And here's the kicker. Through those two failed attempts, Mr. Barton had forfeited deposits and racked up costs totaling exactly £1.2 million. He was seriously out of pocket, and he desperately wanted his money back. To get that cash back, he struck a fairly simple oral agreement in July 2013 with a rep from FoxPace. We can essentially break it down into 3 steps. Step 1, Barton finds a willing buyer for Nash House. Step 2, the target price for that sale must be exactly £6.5 million. And step 3, if that happens, Fox pays Barton his £1.2 million fee, which finally allows him to recoup his lost deposits. It was a clear, one-sided, unilateral contract. But really pay attention to how incredibly specific step 2 is. Okay, moving on to part 2, the problem with silence. In contract law, what you don't say can actually be just as legally binding as what you do say. Now, Mr. Barton totally nailed step 1. He found a willing buyer, a company called Western, who initially agreed to pay the full £6.5 million. But then, cue the twist. The buyer suddenly discovered that the new HS2 railway link was going to affect the site. And because of this massive new development risk, the buyer completely refused to pay full price. So they renegotiated directly with FoxPace, and the final sale price dropped down to £6 million. The property successfully sold, sure, but that crucial £6.5 million target price? Completely missed. So that brings us to the absolutely crucial question. If you don't hit the exact target, do you get nothing or do you get something? You see, the oral contract was totally 100% silent on what would happen if the property sold for anything less than $6.5 million. Mr. Barton argued, hey, I introduced the ultimate buyer, so I should still get my fee, or at least a reasonable chunk of it, right? But FoxPace argued that since the strict condition of $6.5 million wasn't met, they owed him absolutely nothing, zero. That silence basically left both sides at a total deadlock. To figure out who actually owed what, this whole dispute escalated all the way up to the highest legal authority in the land, the UK Supreme Court. The judges basically had to untangle this handshake agreement and decide if the law could somehow step in to fill the gaps left by the parties' silence. Barton's legal team first tried to rely on a concept called implied terms. Basically, an implied term is a provision that isn't expressly stated out loud in a contract, but it's introduced by law to reflect what the parties supposedly intended but just didn't say. A lower court judge had actually calculated that a standard reasonable fee for the work Barton put in would be around £435,000. So Barton argued that an obligation to pay this quote-unquote reasonable fee should just be implied into his contract with FoxPace. But here's the thing, implying a term into a contract is actually incredibly difficult. The court uses this really strict standard known as the officious bystander test. Imagine a super annoying, nosy bystander interrupting Barton and FoxPace right while they're making their handshake deal, asking, hey, what if the property sells for less than $6.5 million? Will FoxPace still pay a fee? For a term to be legally implied, the answer from both parties has to be a simultaneous, slightly annoyed, well, oh, of course. The Supreme Court looked at this exact scenario and said, no way. Given the heavy history of that massive 1.2 million demand, if someone had actually asked FoxPace to guarantee a lower fee for a lower sale price, they absolutely wouldn't have obviously agreed to it. And this really highlights the fundamental difference between Mr. Barton and your standard run-of-the-mill estate agent. An estate agent runs a volume-based business. They have a regular percentage commission structure. So for them, it goes completely without saying that they'll get a cut of whatever the final sale price ends up being. But Mr. Barton, he was a one-off investor desperately trying to recoup a very specific 1.2 million pound loss. Because his demand was so uniquely tied to his past debts, the court just couldn't magically imply standard estate agent rules into his highly unusual high-stakes gamble. This leads us to Part 3, Unjust Enrichment Explained. With both express and implied terms completely failing him, Barton was kind of backed into a corner. So he tried a third legal door, unjust enrichment. This is a legal principle that requires a party to return a benefit if keeping it without paying would be, well, unjust. Barton's argument here was pretty straightforward. He said, look, FoxPace just walked away with £6 million in the bank, thanks entirely to the buyer I found. They pocketed the cash, and they gave me nothing. So he argued they unfairly benefited from his introduction, and it would be fundamentally unjust for him to receive absolutely zero for providing such a valuable service. Now, to win this argument, the court had to evaluate 4 very specific questions. 1, was the defendant enriched? 2, was it at the claimant's expense? 3, was the enrichment unjust? And 4, are there available defenses? Interestingly, FoxPace actually admitted yes to those first 2. They were definitely enriched, and yep, it was at Barton's expense. But they fought fiercely on question 3. They argued that keeping the money wasn't actually unjust at all because Barton knew exactly what risk he was taking. To really explain this concept, the Supreme Court looked all the way back to a famous case from 1795 called Cutter v. Powell. It involved a sailor who was promised a massive payout. We're talking nearly 4 times the normal wage, but only on the condition that he completed the entire voyage. Tragically, he died before the ship actually arrived, and his widow sued for a portion of the wages. Well, the court back in 1795 ruled that when you structure a contract as a one-way bet, a high-risk, high-reward scenario, you have to take the loss if you fail to hit the exact condition. And the Supreme Court applied this exact logic to Barton. He had bargained for a massive payout of $1.2 million, which was almost 3 times the normal market rate, strictly on the condition the price hit $6.5 million. He took a one-way bet, and unfortunately for him, he lost. Finally, let's look at Part 4, the final judgment. So, did Barton's silence really cost him his entire payout? Delivering the fatal blow to his case, Lady Rose, who was writing for the majority, delivered this incredibly powerful quote: "Unjust enrichment mends no one's bargain." What she meant is that because Barton and FoxPace expressly defined the exact trigger for payment, that £6.5 million sale, the law simply cannot step in and rewrite the contract just to save Barton from a bad deal. He took a massive risk to get his lost deposits back, and the court flat out refused to use unjust enrichment as some sort of backdoor to bail him out. But honestly, it's fascinating because the top legal minds were actually deeply divided on this. Lady Rose led the majority, concluding that contract silence means there is absolutely no obligation to pay. The risk was entirely Barton's. On the flip side, though, Lord Legate wrote a very strong dissenting opinion. He argued that when someone provides a genuinely valuable service, like finding a multi-million-pound buyer, the default rules of reasonable remuneration just have to apply when a contract is silent. He firmly believed that unless FoxPace expressly stated, hey, we'll pay you nothing if the price drops, Barton was legally entitled to that £435,000 market value for his work. But as you know, in the Supreme Court, the majority rules, and Lady Rose's incredibly strict contractual interpretation won out. So as we wrap up this explainer, we're left with a stark million-pound warning. Mr. Barton risked a massive payout on a single, highly specific condition, and he left the entire rest of the deal to a handshake. So next time you make a deal, what will you leave unsaid? Because as the Supreme Court made absolutely clear today, when you leave the details out of your contract, you might just be negotiating your way into getting absolutely nothing. Thanks for joining me on this explainer, and I'll catch you next time.